Huge news. The motion to vacate alleging fraud upon the court in the SEC's case against Reggie Middleton has been filed. And wow, there's some new evidence in there, and I'm going to break it down for you. But before I do, a quick disclaimer. Give her a pause, read it, and I'm going to move on. All right, let's get into this. So here we have a post showing the motion to vacate was filed on Friday, May 30th, 2025. And we have three documents here that were filed. We have document number 118, which is the motion to vacate, 119, which is the memorandum in support of, and 120, which is the affidavit or declaration from Reggie's attorney, Jason Siebert. So I spent all day yesterday going through the motion along with the memorandum of support and Jason Siebert's affidavit along with all the exhibits. And I created this summary article here, which I'm going to go through right now. But as you can see, the motion is only one page, and I'm going to read this for you right now. The defendant's FRCP 60D3 motion to vacate order for fraud upon the court. Defendants Reggie Reginald Middleton, Veritaseum Inc. and Veritaseum LLC respectfully move the court to vacate DE 61 consent order and judgment for fraud upon the court, as well as returning defendants' assets, dismissing the complaint without prejudice, and awarding attorney fees and costs since August 2017. Through the completion of these proceedings for the reasons set forth in the supporting memorandum, declarations, and exhibits attached thereto. And of course, you can see this is signed by Reggie's attorney, Franklin Jason Siebert, from Siebert Law. Now, this is the article that I wrote. Crypto Inventor accuses SEC of fabricating evidence to win case. In a dramatic legal showdown, Reggie Middleton, the innovative mind behind Veritaseum, a blockchain-based financial technology company, is accusing the Securities and Exchange Commission, the SEC, of resorting to deceitful tactics to secure a victory against him. In a motion filed on May 30th, 2025, Middleton and his companies Veritaseum Inc. and Veritaseum LLC allege that the SEC fabricated evidence and intimidated witnesses to obtain an asset freeze that ultimately coerced him into a settlement, in which he neither admitted or denied the allegations against him. Quote, the Securities and Exchange Commission fabricated evidence that Reggie Middleton stole investor assets in order to obtain an asset freeze, end quote. The motion boldly declares, and this is a link to the memorandum of support. And this echoes a troubling precedent set in the SEC versus DebtBox case where the SEC faced sanctions for similar misconduct. And I'm going to touch on that a little bit later in the article. The genesis of the dispute. The saga began in August 2017 when the SEC launched an investigation into Middleton and his companies, suspecting them of raising $14.8 million through an unregistered initial coin offering, or ICO, and subsequent sales of VERI tokens between April 2017 and February 2018. The SEC alleged violations including unregistered security sales under Sections 5A and 5C of the Securities Act, fraudulent misrepresentations under Section 17A and Section 10B of the Exchange Act, and price manipulation under Section 9A2. Middleton, however, steadfastly maintains that VERI tokens were utility tokens, tools for accessing the Vader platform, not securities, a distinction central to his defense. And again, all this can be found in the Memorandum of Support, pages 9 through 11, linked right there. So this is where it gets a little interesting. So the investigation began with a phone call from SEC attorney Jorge Tenreiro to Middleton's counsel, Franklin Jason Siebert, threatening subpoenas if cooperation wasn't forthcoming. Siebert, keen to collaborate, requested clarity on whether a formal order of investigation existed, but Tenreiro remained evasive and stated that he needed to see quote-unquote magic language in order to provide it. Further, the SEC acknowledged that there in fact was an unpublished modification to the enforcement manual that impacted defendants' due process rights, but the SEC and Mr. Tenreiro refused to provide those updates. This set the tone for what Middleton now describes as quote-unquote calculated scheme to undermine his business. Okay, and we can see here that there's two links, one to Jason Siebert's declaration on page 3 and memorandum of support on page 8. So going to the declaration of Jason Siebert, we go to page 3, and here we see, I responded that I wanted to see a copy of the formal order of investigation and did not accept or deny service of the subpoena. Mr. Tenreiro responded requesting, quote, magic language, end quote. And then if we go to the memorandum of support, we see on page 8, Further, the SEC acknowledged that there in fact was an unpublished modification to the enforcement manual that impacted defendants' due process rights, but the SEC and Mr. Tenreiro refused to provide those updates. Then, on October 26, 2017, with full knowledge that no subpoena had actually been served upon defendants, Mr. Tenreiro demanded a response to the unserved subpoena within 24 hours, or else he would pursue civil enforcement. So this is interesting to me because it seems like Mr. Tenreiro is acting on his own accord and forcing responses to unserved subpoenas with the threat of civil enforcement. So again, I'm not an expert, but that does seem to set a tone as mentioned in the article. The alleged fraud, a misrepresented Kraken account. At the heart of Middleton's allegations is a claim that the SEC misrepresented the ownership of a Kraken exchange account to secure a temporary restraining order, TRO, and asset freeze in August of 2019. During the TRO hearing, Tenreiro asserted that Middleton transferred over $2 million to his, quote, personal accounts after receiving a Wells notice on July 26, 2019, suggesting a risk of asset dissipation. Quote, Mr. Middleton, after being notified of the Wells notice, transferred over $2 million to his personal accounts, end quote. Tenreiro told the court, painting a picture of a defendant scrambling to hide funds. And now Doc 120-9 leads us to a transcript of the TRO hearing. So this is 49 pages, page 11. And this is where he's talking about the asset dissipation and transferring the $2 million. However, Middleton contends that this was a blatant lie. The Kraken account, he argues, belonged to Veritaseum LLC, not him personally, a fact that the SEC knew but concealed. Evidence supporting this claim emerges from the SEC's own proposed TRO order, which listed the Kraken account as belonging to Veritaseum LLC, and this can be found in the Memorandum of Support on page 15. Furthermore, a supplemental declaration from SEC blockchain data scientist Patrick Doody later acknowledged the account's corporate status, contradicting his first declaration that labeled it as Middleton's personal account. So we've got a couple links here. This first link is going to take us to a table which is actually just below here, and I'm going to cover that in 1 second. And the Memorandum of Support here on page 10 and page 13 show Patrick Doody's declarations, and I'm actually going to skip right to Patrick Doody's second declaration. You can see his signature here at the bottom. And if you go to the top, it says, in my first declaration, I referred to a certain account at Kraken, a digital asset trading platform, in describing the flow of digital assets from the ICO as an account, quote, held by Middleton, or as, quote, Middleton's Kraken account. And if you go a little bit lower here, I understand now that the account is titled in the name of Veritaseum LLC. And you can see that right here. So below is a table found in the Memorandum of Support on page 15, showing during the TRO hearing, Mr. Tenreiro himself admitting the Kraken account was in fact, quote, business addresses. And this can be found in document 120-9. I'm going to show you that in 1 second. Following this, Judge Hall, quote, decided not to freeze Mr. Middleton's personal accounts, but instead only those of the business, end quote. Again, confirming the corporate status of the accounts. And this can also be found in the same document. The court continued by asking, quote, now, can someone tell me with respect to the Kraken account, is that a traditional bank account? Mr. Tenreiro, it's not a traditional bank account, but it's an account that we can serve a freeze order on, end quote. Emphasis added. And again, this is in the table that's shown right here, highlighted. And now I'm going to show you where they can be found in the actual documents. So this here is page 29, line 15. Mr. Tenreiro, the blockchain addresses are, I suppose, business addresses. The only person who controls that is him. He has the key. And interesting, if you go down just a little bit, it says here, Mr. Tenreiro, I'm sorry. We put account in. Essentially, the way we think about it is addresses. So here he's clarifying that he's talking about the Kraken account being blockchain addresses. So then if we scroll down to page 40, right here. Now we can see the judge asking, now can someone tell me with respect to the Kraken account, is that a traditional bank account? Mr. Tenreiro, it's not a traditional bank account, but it's an account that we can serve a freeze order on. So again, in the same document. So it's really important to make note of this. This is the TRO hearing transcript, and this was conducted on August 12th, 2019. Now, if we go back to Patrick Doodie's second declaration, where he corrected his first declaration stating that the Kraken account was in fact titled under the name Veritaseum LLC, a corporate account, we see here at the top that it was filed on August 22nd, 2019, 10 days after the TRO hearing. And on this very same day, Tenreiro, Suthmanot, and Willenkin submitted their memorandum of law supporting the asset freeze on that very same day, August 22nd, 2019. And they failed to correct the record, still pushing the narrative that this was a personal account. 10 days after Tenreiro admitted himself in the TRO hearing that the Kraken account was in fact business addresses. So there's a few different ways we can prove that the SEC knew that the Kraken account was a corporate account. And one of those ways is here with an email from Covington to Jorge Tenreiro himself on July 16, 2018. This is over a year before they issued the temporary restraining order, and we can see here the Kraken account number that was sent to him. And this was filed with Veritaseum's reply to the TRO. They issued a 423-page reply, and this is one of the pieces of evidence that was included in that. Also, we see here Reggie Middleton, a New York resident, points out that Kraken is not licensed to do business in New York, making it impossible for him to have a personal Kraken account, as found on Kraken's support page under geographic restrictions. And this is linked here, and we can see here a message from Reggie to Eleanor. It has to be for the LLC. Kraken is not licensed to do business in New York. And here you see the geographic restrictions. At this time, Kraken does not offer services or service to residents of Maine, New York, and Washington State. New York obviously being the one of interest. In reference to the $2 million alleged as dissipation of assets, Middleton's attorney David Kornblau countered during the TRO hearing that these transfers were routine business transactions, occurring every 6 months for 18 months, and fully disclosed during the SEC's 2-year investigation. Quote, what I found out is roughly 6 months before he had transferred the same amount, and roughly 6 months before then he had transferred the same amount, end quote. Kornblau explained, and this is found in document 120-9 on page 12. Yet the court, relying on the SEC's narrative pushed by Tenreiro, quote, so I don't have anything to balance their argument but to accept it as true, end quote. And this is found in the memorandum of support. Judge Hall granted a modified TRO, freezing business assets and ordering expedited discovery, as found again in document 120-9, page 35. Witness intimidation, silencing the defense. Adding fuel to the fire, Middleton alleges that SEC intimidated witnesses to suppress testimony in his favor. Affidavits from Michael Shahan and Lloyd Cupp paint a chilling picture of coercion. Shahan, a Veritaseum community member and beta tester, submitted an affidavit supporting Middleton in August 2019. The SEC swiftly subpoenaed him for a deposition, which he describes as, quote, aggressive, abusive, and threatening, end quote, with threats of felony charges for his support and YouTube activity showcasing the Vader platform. Quote, it was clear that the meeting was intended to scare me into silence, end quote, Shahan wrote, noting that the ordeal cost him his YouTube channel and halted his advocacy. And this is found on document 120-11, page 2. Similarly, Cupp recounts an unsolicited call from Tenreiro in June 2018, urging him to testify against Middleton as a victim of a Ponzi scheme. When Cupp refused, asserting VERI's utility status, Tenreiro pressed him to reconsider. Quote, I told Mr. Tenreiro that I did not consider myself a victim, end quote. Cupp affirmed, rejecting the SEC's narrative, and this is found on document 120-12, page 2. These actions, Middleton argues, were designed to chill exculpatory testimony, further corrupting the judicial process. A pattern of misconduct? Middleton's motion draws a striking parallel to SEC versus Digital Licensing Inc., or DebtBox, where a Utah federal judge sanctioned the SEC for $1.8 million in 2024 for fabricating evidence to obtain a TRO and asset freeze. In that case, the SEC falsely claimed DebtBox closed 33 bank accounts in 48 hours and liquidated $720,000, misrepresentations the court deemed, quote, materially false and misleading, end quote. Document 119, Memorandum of Support, page 4. The judge emphasized the SEC's, quote, special duty to act with integrity, end quote, a duty Middleton claimed was breached in his case as well. The defendants highlight a pattern of pre-litigation misconduct, including threats to enforce unserved subpoenas and attempts to use a forged document during Middleton's testimony. Sieber's declaration details how Tenreiro mocked Middleton during a November 2017 interview and tried to impeach him with a fabricated document, only exposed when breaks were denied. And this is from Jason Sieber's declaration on page 5. This, they argue, reflects a broader strategy of dishonorable behavior, violating the SEC's duty under SEC versus ESM, government securities to act honorably. And this is found in the Memorandum of Support, page 3. The coerced settlement. The case culminated in a consent judgment on October 31, 2019, imposing $8.47 million in disgorgement and $1 million civil penalty on Middleton. Even though Middleton neither admitted or denied these allegations, he contends that the outcome was not a fair resolution, but a forced capitulation, driven by the asset freeze that left him unable to fund his defense. Quote, the TRO's pressure, coupled with the subsequent intimidation and concealment, left Reggie Middleton with little choice but to settle, end quote. The motion states, and this is in the Memorandum of Support on page 17. The defendants now seek to vacate this judgment under Federal Rule of Civil Procedure 60D3, which allows courts to set aside judgments for fraud on the court, intentional misconduct by officers of the court that corrupts judicial integrity. They argue that the SEC's actions meets this standard, supported by clear and convincing evidence like the TRO hearing transcript and witness affidavits, as seen in the Memorandum of Support on pages 19 and 20. A questionable witness and flawed evidence. Further bolstering their case, the defendants point to the SEC's use of Michael Middleton, no relation, as a witness, whose declaration claimed investment losses. Yet his deposition reveals a traumatic brain injury affecting his memory, casting doubt on his reliability. Quote, I was in a coma for 2 weeks and I have some brain damage, end quote, he admitted. Unsure of basic details about his alleged investments, the defendants question why the SEC relied on such a witness, suggesting it was a desperate move to prop up a weak case. And again, those can be found on document 120-10 on pages 14, 15, and 17. Additionally, SEC staff accountant Roseanne Daniello's financial analysis contained errors she later corrected, undermining the dissipation narrative. Quote, her August 12, 2019 declaration represented as certain fact totals for various international wires, which she later admitted were incorrect, end quote. The motion notes in the Memorandum of Support on page 12, highlighting the SEC's rush to court with incomplete data. The stakes and what's next. Middleton's motion demands the judgment to be vacated, his frozen assets returned, the complaint dismissed without prejudice, and attorney fees awarded since October of 2017. Alternatively, they request an evidentiary hearing to probe the SEC's actions. The stakes are high. A ruling in Middleton's favor could signal greater accountability for regulatory overreach, particularly in the cryptocurrency space where unclear rules often clash with innovation. The SEC may counter that the motion is untimely, coming 5.5 years after the judgment, or that Middleton settled knowingly, waiving his claims. Yet FRCP 60D3, fraud upon the court, has no time limit, and precedents like Pumphrey versus KW Thompson Tool Co. suggest settlement doesn't bar relief if fraud is egregious. The discrepancy between the SEC's filings and the Kraken account's ownership, coupled with witness intimidation allegations, presents a compelling case for judicial review. Broader implications. The cryptocurrency industry has long decried the SEC's aggressive tactics and murky guidelines. Middleton's fight adds a potent narrative to this critique, suggesting the agency may bend the truth to win. Whether Judge William F. Kuntz II vacates the judgment or orders a hearing, the outcome will reverberate through the crypto community, challenging the power dynamics between regulators and innovators. As the battle unfolds in the Eastern District of New York, one truth emerges. Middleton's allegations, backed by court documents and sworn affidavits, demand scrutiny. For now, the question lingers. Did the SEC play fair, or did they stack the deck to silence a blockchain pioneer? So just to recap some of the new evidence that we found in the motion to vacate, we have Jason Siebert's declaration, where he states that Tenreiro openly mocked Reggie during an interview in November 2017 and tried to impeach him using fabricated evidence, which I believe was a forged document with Reggie's signature on it. Also, Jason Siebert requested clarity on whether a formal order of investigation existed, but Tenreiro remained evasive and stated that he needed to see quote-unquote magic language in order to provide it. Further to that, we also have Tenreiro himself admitting that the Kraken account addresses or blockchain addresses are quote-unquote, I suppose, are business addresses. The only person who controls that is him. He has the key, end quote. So Tenreiro openly admits in the transcript of the TRO hearing that the Kraken account addresses are business addresses. And the Judge Hall, during the transcript or during the TRO hearing, also admits that the Kraken account was a corporate account. It seems like it was a little bit of an oversight here, but as she's going through the list of accounts that are personal and corporate, she decides not to freeze personal ones and only the corporate accounts, and the Kraken account being one of them that was frozen, proving again that it was in fact a corporate account. We also have evidence of witness intimidation with affidavits from Michael Shahan and Lloyd Cupp, and should we go to trial, I think those are going to spawn off to other instances of fraud upon the court, such as the Vader platform, functionality, and operability. Reggie went in and demonstrated the Vader platform to SEC staff, and days later they told him to shut it down. And then Tenreiro came back and said that the platform wasn't functional. So they told him to shut it down and claimed that it wasn't functional. And of course, this leads us into VTest's channel, where he does tutorials or has done tutorials on the Vader platform, proving that the platform did exist, but of course he was coerced into shutting down his platform with threats, aggressive, abusive, and threatening tactics, and threats of felony charges for his support and YouTube activities showcasing the Vader platform. So I think we have some pretty strong evidence here, and I'm pretty excited to see this unfold. It's been a long time coming, and I guess I'm going to take us over to here. We have some dates. So we just had May 30th, where the defendant's moving papers to be filed. That was the motion to vacate that we just went through. And on June 20th, we have the SEC's opposition, if any, to the motion to be filed. So June 20th is our next date. I got to be honest, I think the SEC is probably going to fight this. I don't know if they have much choice but to. But there is a chance they could negotiate a deal with Reggie. I don't really know. But yeah, should the SEC file any opposition papers, we have June 27th as another date for the defendant's response to the SEC's opposition. So I wanted to thank a VERI community member that sponsored this video. He wanted to remain anonymous, but I wanted to give him a thank you anyway, along with all the other VERI community members that have helped with donations to help support my effort in creating this content. If you like my work, you can follow me on X, Substack, YouTube, and Rumble, and Reddit, all at Sovereign Riz. And I hope to see you next time.